thank them for their willingness to serve with us. So the first item of business under old business, we have minutes from February 1st and February 15. Are there any questions or comments on those minutes? Matt, do I have a motion to approve?
I'll move it.
Lynn, you give you a second?
Second, yep.
Any opposed? Any comments or concerns? None? All right, all in favor, and since the town council is able to do this by calling the roll as opposed, because it's a Zoom. Matt,
Yes.
Lynn,
Yes.
Sibel,
Yes.
and Austin.
Yes.
All right, great. Well, we've got a vote of and mine, yes, 5-0. Now, we're waiting
There's
for
Bruce.
Mr. Cobb. There
He's
he is. Good, good. Well, earlier today, I informed Mr. Delory that we would be moving his case to second position and starting with case number 2196, which is the Barley Neck Inn. And Mr. Delory graciously agreed to accept that second position tonight. I think to begin this case, I'd like to call on Town Council Mike Ford to give us a history of why it's here, what we need to do, and what the issues will be tonight. Mike, it's all yours. Take it away, please.
Thank you, Mr. Chairman, and members of the Board of Appeals and any members of the public. Our counsel for both parties here, Ms. Mulligan, is
You know, is Peggy on the Zoom tonight?
Yes,
Yeah, is our John Kanaga, and who's the other counsel, Mr. Ford? Victoria
The
Douglas?
hand raised.
I'm sorry.
Their hands are raised to be let in.
Oh, I don't
yeah,
know.
they should be let in before anything starts,
Yeah.
Mr. Chairman.
All right, would you let in John Kanaga, and is it Victoria Domus? Is that who's on the?
Yes, yes, it
Yeah,
is.
Victoria Domus.
And really, Mr. Chairman, if there's anyone else in the waiting room that came here for this case, they should be allowed to hear it, as long as they can hear it. I mean,
Yeah, I think they all can hear it, isn't that? Is that right, Jen, that everyone can hear? Even if you're not on the screen, you can hear and follow the proceedings. Is that correct?
I believe
is
so, yes.
okay. All right.
Is there any reason not to have them on the screen if they were all muted?
Well, it depends how many people you get. The screen gets pretty small, Mr. Todd.
Fair enough, fair enough. Thank you.
Mr. Kanaga, oh yeah, you're on here. Okay, good. Everybody's here, I think, Mr. Ford.
Okay, thank you. So attorneys Damas and Kananga, the chairman of the board has asked that I simply walk the board through a little bit of the history of this case procedurally, so and kind of tee it up as to what they're looking at this evening. And I will tell you, Mr. Chairman, I did call each one of the council today and let them know that you had asked me to do that and that I would be doing that, so they're aware of that.
Good.
So this particular matter has its genesis in a decision the board issued a little less than a year ago regarding the Barley Neck Inn. And you had before you an appeal.
Mr.
Yes.
Ford, may I interrupt for 1 second? It's my fault. Sibel is recused herself on this case, so Austin will be voting as the 5th member of the board. So I just wanted to go on the record that Sibel is recused because of her proximity to the location. So,
Okay.
thank you. Sorry.
Thank you for putting that on the record. So, as I said, this case has its genesis in a decision that the board made a little less than a year ago, May of 2022, in which the board overturned a decision of the building commissioner that had been appealed to your board. The decision of the building commissioner was that outdoor entertainment at the Barley Neck Inn triggered the need for the Board of Appeals to make what's called a Section 6, Chapter 48, Section 6 finding that that entertainment was not substantially more detrimental to the neighborhood than operating the inn without it. And the building inspector reasoned as a result of that, that a special permit was needed for that activity. The board, after hearing a full evidentiary hearing on the matter with all parties participating, determined that it did not need a Section 6 finding, that the use was customarily consistent with the prior use, and under the powers test, did not rise to the level of something that needed a special permit, and issued a decision in a 4 out of 5 vote overturning the decision of the building commissioner. That decision was appealed by Attorney Dalmas's clients, and the matter has been before the land court. And while it hasn't had any evidentiary hearings in the land court on the issue, there's been considerable discovery, and a lot of information is exchanged hands in the course of that discovery regarding the history of the inn and its operation. And perhaps most importantly, the two parties who are the real stakeholders in the case have come to an agreement. And that agreement consisted of a couple of different things. First, they agreed that the matter would be remanded back to the zoning board, and the court, in response to that agreement of remand, did remand the case back, and that is what is before you tonight. They further agreed that when the matter was remanded back, that the inn, BNI, would make a request to the board that you reconsider the action that you took last May in overturning the decision of the building commissioner. And if you vote to reconsider, the effect that has is simply it takes away the vote to overturn the building inspector and just puts the matter back on the table again, so that it's an open question again at the board. So it doesn't do anything with respect to whether you made a correct decision or an incorrect decision. All it does is, if you reconsider it, which is what all parties are requesting you do, it puts the matter back before the board again in the exact posture it was in before you made that prior decision. If you do that, at that point, it's my understanding that Mr. Kananga, and he's outlined it in his letter, I think, very clearly, he, on behalf of the inn, will then request that the appeal of the decision of the building commissioner, which he brought before the board on behalf of his client, he's going to request that that be withdrawn. And the board will then act on that request for withdrawal. If the board decides to honor that request for withdrawal, for which the neighbors have no objection, they've joined in this, he will then ask you to open the hearing on a special permit application that he has filed with you. And he will then proceed to put the case in for a special permit for outdoor entertainment at the inn, the scope of which is entirely different than what was before the board the last time. In many ways, but in one principal way, it's not amplified music or live music that he will be asking for, but it's all outlined in his special permit proceeding. Finally, at the conclusion of his presentation of the evidence, he will ask that when you act favorably upon the special permit, which he hopes you do and the neighbors do as well, there's a set of conditions which his client has worked out with the neighbors that will govern, most importantly, the noise that might emanate from an outdoor activity. There's a document entitled the Noise Protocol, and he will ask that that be included as part of the decision. Before the matter was agreed to be sent back by the land court, I appeared before this board in executive session, and I discussed the request that the two parties had made, they had come to an agreement, and they asked the town to join in their agreement. And I indicated that my recommendation was that I join in the agreement for the sole purpose of allowing the matter to be remanded back to you so that you could make a decision on the newly filed special permit. The reason my execution of the agreement was limited to that was that I couldn't act for the board, and the board frankly can't make changes in their decision without holding public hearings, for which the public has a right to appear and comment. And that's why we're going through this procedural process where they're going to ask you to reconsider the prior vote at a public meeting, and you can discuss that particular request and then make a decision on it. And then they're going to ask you to withdraw if you vote to reconsider, and that's all done at a public meeting. And those are the things that I agreed to on your behalf to allow to occur. And you may recall the board members who were present that evening, I think there was 4, voted unanimously to authorize me to execute the settlement agreement for that limited purpose only. In other words, that you agreed that the matter should be sent back and that you would then hear the request for reconsideration, act on it, and you'd hear the request for withdrawal. So that's where it is procedurally. And I'm happy to answer any questions. If there are procedural questions that you have about anything I just said to you, I'm happy to try and respond to those now. But if you're all comfortable with what is about to occur here from a procedural standpoint, then I would suggest you can simply proceed with the hearing.
Thank you, Council Ford. So the first item of business is to has been a motion for us to reconsider the issue of our prior hearing. That's correct.
That's
Just to
correct.
reconsider, to reopen the issue as it were.
Right.
Is there any comments or questions about that? Do I have a motion to reconsider our prior decision, I guess?
Mr. Chairman, my apologies.
So moved.
Mr. Chairman, my apologies. I have a hand up. I don't know how else to do it. May I speak?
What's that, Mr. Tom?
May I speak?
Oh, yeah, please do. Please do.
Mr. Ford, what I don't understand is why isn't the prior matter simply a nullity and they appear here anew?
The court has never overturned the decision of the board. It has never been tried. And the parties by agreement can't agree that a decision of the board is a nullity. The board has to take an action here. And so
the fact is that we were approving their motion to withdraw or to reconsider.
they've made a request in their letter as a first order of business, Mr. Taub, that you reconsider the prior vote. That will have the effect of avoiding that decision and putting it back on the table in front of you. And they are then going to ask that it be withdrawn. And so that decision.
Oh, okay, I got it. I'm sorry, Mr.
All
Ford.
right.
I got it. Thank you.
Okay, thank you, Mr. Taub. I think you had a motion to reconsider on the
You had a
table.
motion to reconsider, Lynn. I think you made that
Second.
motion. Second by Matt. All right. Are there any comments or questions before we vote? All right, we'll call the roll. Lynn? Lynn, you want to vote on the motion? I think she's frozen there. I know what's happening.
Yes. Yes.
Okay, thank
You
you.
can't hear me?
Yes, we can.
Yes.
Yes, we can now, yeah. Mr. Cole,
Yes.
Mr. Higgins,
Yes.
Mr. Taub,
Yes,
and I'm also yes. That's unanimous vote to reconsider the motion. Now, the next is as a motion to withdraw.
Well, it's not a motion. Mr. Kananga, I'll let him speak for himself, has made the request, if you reconsidered, which you have, that he be permitted to withdraw the appeal that he took of the building commissioner's prior decision. He's stated that right in his letter to you.
All right,
So,
okay.
Mr.
Yes.
Kananga, you might want to make that officially on behalf of your client.
I would, although I like your wording better, but so step 2 in the process, we're formally requesting to withdraw the original of appeal in this case of the building commissioner's determination.
All right, so we have a motion, we have a request for a motion to withdraw the appeal of the building commissioner's prior determination. Do I have a motion to allow that withdrawal?
So moved.
Is there a second?
Second.
All right, are there any comments or questions about that? Before we move to a vote? All right, Ms. Icoll,
Yes.
Mr. Cole,
Yes.
Mr. Taub,
Yes,
Mr. Higgins,
Yes.
and I'm also yes, so that's unanimous. So, Mr. Kanaga, now you're going to move to open a new hearing?
Yeah, good evening, everyone. I'm John Kanaga, and I represent the Barley Neck Inn and its owners, the Ruggieris, as well as their company Buffer Zone Properties LLC, which is the company that owns the lot in question. And we're here under a special permit request, which is step 3. I wasn't quite sure how it was going to go, but you did that very quickly, so I appreciate that. And I'll just jump to my special permit application. This is a new application for an alteration to a pre-existing non-conforming use under Orleans zoning bylaws. Upon discussion and eventual settlement with the abutting neighbors, as Mr. Ford pointed out, the abutting neighbors to my client's property, all parties have come to an agreement that I believe benefits them all going forward in regards to the use of the front lawn of the site. My client is applying for a finding under MGL 40A section 6 and its corresponding provision in the Orleans zoning bylaw, which is section 164C2. It's a so-called section 6 finding, the special permit to allow it to continue outdoor entertainment and food and beverage services subject to, in accordance with the attached protocols, which are very specific, and to have those incorporated in the special permit if you would grant it tonight. The Orleans zoning bylaws mirroring the general bylaws of the Commonwealth. Section 164(3)(C2) allows other non-conforming structures or uses may be altered, reconstructed, extended, or structurally changed on special permit from the Board of Appeals if the Board of Appeals finds that such alteration will not be substantially more detrimental to the neighborhood than the existing non-conforming structure or use. And that's substantially more detrimental was subject to a lot of our last discussion on this issue. But we ask tonight that the board firstly makes the section 6 finding that the proposed outdoor entertainment and food and beverage use on this property in accordance with the attached protocols is not substantially more detrimental to the neighborhood than the lawful use prior to the 1971 zoning change, which rendered the property lawfully non-conforming. In support of the board so finding, the applicant, in concert with the abutters, has carefully put together outdoor use protocols for the proposed outdoor entertainment and food and beverage operations, which meet the standard, not substantially detrimental, given the limited exterior operations and the proposed measures ensuring adequate acoustical protection of the abutting residences. So generally I'll go through, would you like me to go through the 8 steps for the board, or?
I think well, I
I'd
don't
like
think.
it on the record.
What's that, Mr. Tom?
I'd like it on the record, please. Thank
Okay.
you.
So under section 16444 of the Orleans zoning bylaw, the board is authorized to issue a special permit in this matter when it determines that the use will not be detrimental to the established or future character of the neighborhood and the town, and will be in harmony with the general purpose of the intent of the chapter. In doing so, you're instructed to consider the following 8 criteria. The first is that the site is adequate for the proposed use. There's no increase in patron use. The restaurant seats as defined by our nutrient management plan and state code will not change. The wastewater flow won't change. The second is that the site is suitable for its proposed use. The site is operated as a restaurant, bar, and inn with entertainment and liquor licenses for over 50 years. It's pre-existing non-conforming in the rural business district, but it is lawfully conforming. As a result, it's suitable for the lawful purpose. The proposal will not impact traffic flow or safety within the neighborhood. The traffic flow won't change from its current use. They're not allowed any more capacity under Title V or the nutrient management plan. The front yard remains open. And I think it's of note, the current owners will be using signage and have staff aware of parking off-site, as there have been problems in the past with people parking on the neighbor's property. It's not necessarily germane to this. I just wanted to make a point of it, specifically one neighbor's front lawn. And it should go without saying, but my client will be saying it, not to park on that person's front lawn. The proposal will not impact the neighborhood's visual character. There's no change to the use or buildings on the site. The method of sewage disposal, source of water and drainage will not change. The utilities are not increasing or decreasing. And probably the most important is the seventh issue to consider. It's the proposed project will not cause any undue noise or litter. So this is probably the most important for this permit. Under our settlement agreement with the abutters, the proposed use, as outlined in the attached protocols, will not cause any undue noise or litter. The protocols specifically address the amount of people allowed and the acceptable decibel level of the background music, which will remain below ambient levels of summer noise in the surrounding neighborhood. And just for reference, there will be no live music. There was a lot of differentiation before, of what was going to be done, played or not played, but no live music. It's only background music pursuant to the protocols. I think there may be some concern about enforcement of these protocols, and that's why Attorney Dalmas and I took a lot of time to craft them as they currently read. And I think the beauty of the agreement is that the building commissioner has the right to rely on the reports rather than having to go out and inspect or get new equipment or new staff, or it's not putting a burden on him because there's specific equipment that can prove or disprove, and pursuant to the protocols, it's a burden on the property owner to show it. So I think part of the protocols call for the establishment of a sound ceiling for the outdoor speaker. And with the help of an acoustical engineer, which through this case, I've found out more about acoustical engineering than in 4 months than I found out in my entire life.
And more that the building commissioner wants to find out about too.
Yes. So I'll keep Tom out of the acoustical engineering business. But I think the protocols, they call for this a ceiling, and it's going to be set at a certain time of year, and we're confident that the ceiling won't be breached, partially because my client will not allow it. And I think that'll build some trust with the neighbors by not allowing it. But the standard imposed makes passing traffic, for example, in the summer will be at a much higher decibel than the music to make it, effectively inaudible. I think it was 35 decibel, which will only be happening during a limited hours of operating the system. So it's of note that, and I'm probably not breaking news anymore, as Mr. Bray's article today announced the new management, but the new management's keenly aware of the entire situation. Cameron and Tyler Hadfield will be taking over management of the BNI, and the Ruggieri's are excited about it, but they're very well aware of the protocols as well. And then the eighth consideration is the proposed change in use will not have a detrimental effect on the groundwater quality, recharge volume, and water quality of coastal freshwater bodies. These will not, valuable resources won't be impacted. And so under previous consideration, there were several abutters who opposed this project vehemently. However, after coming to agreement, both the abutters that were petitioners in the land court stand here with me as petitioner in concert. requesting, I suppose non-ironically in concert, requesting the board grant the special permit as stated and in accordance with the protocols we've agreed to. So there's our request.
Thank you, Mr. Kanaga. Just a matter of housekeeping before we open up for discussion. Mr. Ford, we moved to allow Mr. Kanaga to withdraw his prior appeal of the commissioner's order. Then we just went to the discussion of a special permit. Did we need a motion to allow him to file a special permit or to hear? Mike, you're muted, Mike.
I'm sorry. No, once once the withdrawal was allowed,
Yeah,
then the special permit that he filed gets acted on like any other special permit. He doesn't need permission. It's an application that he's petitioned for.
thank you. All right. I think before we open up for questions with the board, we should ascertain if there's anyone out in the public, because this was a hotly contested issue when we heard it last time. If there are members of the public out there who wish to be heard in favor or in opposition. Is there anyone out there who's looking to speak on this issue? Becky, do you see anybody out there? No. I don't know how we communicate.
No hands raised.
No hands are raised. All right. All right, now I'll turn to questions or comments by the members of the board. I'll start off with my question, Mr. Ford, directed toward you. This seems to be getting into detail and specifics way beyond the purview of the ZBA into territory that is not, you're getting to noise protocol. I think it bumps into licensing board, maybe. So could you address whether this is appropriate? These conditions would be appropriate for the ZBA to apply in their decision?
Yeah, good question. So the question of whether or not a bar like this can have outdoor entertainment is clearly a zoning question, a land use question. And that's the first question that's before you, as to whether to allow this outside entertainment. And that's, they've offered it under very tight conditions. And they've described the scope of what it will be. But that question is a zoning question. And the licensing board has no authority to allow outdoor entertainment if there is a zoning question that has to be resolved first. And so in my view, and I think the case law and the statute is clear on this, this in the first instance is a question for your board. It is clearly within your jurisdiction. Now, assuming that it is, you also have a right to place reasonable conditions. This is a special permit, and your authority to place conditions on a special permit is very broad. And that clearly would include the issue of noise. And why do I say that? One of your 8 criteria of your special permit, the number 7, is noise. So the protocol that has been put together by the parties relates specifically to one of the 8 findings that you need to make on any special permit. You don't usually get this degree of specificity, but here, noise, as Mr. Kananga pointed out, was the major issue. So no question in my mind, this is properly before the board.
All right, a second follow-up to that. This is an agreement between 2 parties with great particularity. It's our ruling, so therefore it stays with the land until changed by another request, I guess. So it lives beyond the life of these 2 parties.
Well, if you grant this special permit, Mr. Chairman, the conditions in it affect the use. So you're not restricting it as to the parties that are involved here.
no,
so,
I understand that.
Like any other special permit that you issue, those conditions follow that special permit. Now, if the property owner decides not to have outdoor entertainment, well, then the conditions are of no force and effect. They only apply to the use that they're seeking here under this special permit tonight. but they apply to anyone who owns the property that attempts to exercise those rights.
All right, and if another party comes in and doesn't use those rights, are they abandoned after a period of years?
If the special permit was not used, I mean, it seems to me if the special permit gets triggered and gets used at some point, then it's been exercised. And once it's exercised, unless it's abandoned later on, it stays in effect.
All right, other questions from the board members? Bruce?
At the prior vote, I was the dissenter, and I think that that's important because I believe that this was in our purview under the terms that it got here, that the building commissioner had said we needed to address this, and there was an appeal, and the whole character of the neighborhood became the major concern for me, and the character of the town, if you will, and to what extent those considerations are part of the legitimate purview of the zoning board, which I clearly believe they are. And so when we got into things like outdoor music, it became a broader general question for me than the very, very narrow specific one before us. I'm disappointed, for example, that the live music has been withdrawn. And I don't say that as a citizen alone. I say that as a member of the board thinking about the character of the town, etc. But the accommodations have been made, and I suppose the parties are to be praised for that. And I don't think that there's anything that suggests we should not support this. This question of what the specifics of the agreement are and how much we want to get into the weeds is a different question to my mind, and I'll leave that at that. So I've said what I have to say, Mr. Chairman.
All right, thank you. Anyone else have anything, any comments or questions?
I have a question about the agreement, the noise protocol. So it defines fairly clearly and fairly extensively in points 7 and 8 what actually defines. I guess 6 technically defines the amplified ambient background music. 7 and 8 defines the method to actually quantify that. At the end of section 6, at the end of bullet 6 here, it mentions that in the event of non-compliance with this noise protocol, is the non-compliance as defined there going to be non-compliance of the defined 35 decibel limit? And if that is what triggers a non-compliance, does that have to be measured in the same way as defined as section or parts 7 and 8 in this agreement?
Mr. Kanaga?
Yeah, it's actually that non-compliance is also defined in section 6, and if I'm speaking out of turn, Attorney Dalmas, please feel free to correct me, but the testing standard to begin with to create that baseline, or ceiling, not baseline, is very specific. And then if there's a complaint showing that that it's in violation, which would have to be some sort of, audio test that's based on, it's in section 6. I'm reading quickly. I can't see it right this moment. Then it's on the property owner to prove that it wasn't. And I think the easiest way to basically do that is once that testing protocol has been, once the acoustical engineers have agreed, here's the number, here's where it is, here's the sound that creates, that's the baseline for that specific system. And then put it in a safe and lock it and no one's allowed to touch it kind of thing. I think you can actually set it so that it can never go above that as well. But that's from my perspective and from my client's perspective of not wanting to go through this again, there's going to be that level that's just not going to go over that. And I think when you make that level or set that level in, April or May, when it's probably the quietest or as close to the quietest, the peepers might actually outsing the 35 decibel on the other side of the road. But I think that's when it's set. And then in the summer, the idea, at least from my perspective, is so the neighbors don't really hear it. And it's we had at the burden on, there's two burdens. There's one to show there was violation. There's two to show that you weren't. And neither falls on the town, I think, is the most important part. There's going to be able to be a reliance by the town on the data given to them. A and B, you said the last page or the last sentence of section 6 is pretty clear too. If there's been a complaint and it hasn't been proven that it was incorrect or something was wrong or it's been fixed, it immediately ceases the use of that sound system until it's fixed. I think that was just a catch-all of if there's a disagreement, then shut it off and figure it out. But that's my simple way of putting it, I think. But you are right, it is extensive, and I think good, because it's as to Mr. Mulligan's question to the town council. The reason we were so specific is we were trying to basically define substantially more detrimental as it related to noise. And that was what this came down to, got very specific. And I think with all due respect, when you get a lot of back and forth in zoning cases, in case law, there's a level of trust that needs to be re-earned. So that's where we're starting with the very specific and going forward.
Yeah, I enjoy that there's a quantifiable measure that's defined here very extensively. I think my question kind of gets at if there was the thought that there was a violation from any of the nearby households, what would the burden of proof need to be in order to determine if there was a violation? Would they need to procure the devices to actually make the official measurement?
I found it, by the way. It's in the event of a noise complaint that the amplified system sounds are distinctly audible and substantiated by an audio recording tied to a GPS location at the closest adjacent residential property line. That is a verified complaint. And then the burden then shifts to the property owner. We need to show what the sound was, what it's going to be. If there was a mistake, the thing fell off and broke and made a loud noise or something. I don't know. My client is pretty adamant that that's not going to be an issue.
Yeah, perfect. Thank you. I appreciate the response.
Ms. Thomas, do you want to add anything?
I think it was described well. We wanted to have a quantifiable standard, given that, the more broader non-quantifiable standards end up being two people debating endlessly. And it's not unusual and we worked with acoustical engineers on this, it's not unusual to come to this type of standard. I think the bylaw in the wind turbine context, Mike can correct me if I'm wrong, you also have a standard in that context. And I am seeing a quantifiable standard in more bylaws to address noise issues. It's more scientific, it's more clearly measurable, and technology has gotten quite good to keep abreast of whether the standard is being met.
All right, thank you. Other questions or comments by the board?
Just a clarification, Mr. Kananga, is music going to be piped through some sound system out onto the lawn? Is that the plan?
If we get a license from the. select-
Assuming.
Yes,
And it could be anything. It could be hard rock, it could be classical, it could be whatever, so long as it falls within the decibel limits.
yeah, I think the idea is that general, I was kind of weird, background music that you have at any restaurant when you go and sit, it's just, you're not noticing the person, the table next to you, kind of low ambient, below the seat, and a low level so that it's going to be designed specifically not projecting at the neighbors at all. So there is a system in place that's going to be specifically designed to not affect them.
Well, I've exposed my prejudices to how it was nice to see live music on a lawn in Orleans, but enough said. Thank you.
Hog Island's still open.
Oh, Mr. Ico, anyone else, questions? All right. Well, do we have a motion on the petition for a special permit?
I'll move that we grant the special permit as presented.
Conditioned with the noise protocol as presented, I presume, right? Is there a second?
Second,
Second, all right. Any other discussion?
I'd like to vote last.
All right, you may vote last, Mr. Tom. Mr. Cole,
Yes.
Ms. Ico,
yes.
Mr. Higgins,
Yes.
I'm also a yes.
I abstain. I abstain.
You abstain. All right. Well, the permission is granted and the permit gets a 4 to a 0 to 1 to vote. And congratulations, Mr. Kanaga and Ms. Adamas, and I congratulate you both on working out this very complicated and testy problem. The town
you.
is benefited, I think, by your cooperation.
Thank you. I just have one question. Do you also need to do, and maybe Mike can answer, do you also need to reflect the section 6 finding as well as the special permit?
I think we do, yeah.
Yeah. I agree. There's nothing to be lost by doing so, Jerry.
No, it may be incorporated in the special permit, but I, like Mr. Taub, believe that there's nothing to be lost by including it in the motion. So if you want to add that to your motion, that you're also making a section 6 finding that this will not be substantially more detrimental to the neighborhood, it would be good.
All right. Mr. Cole, you'll accept that amendment to your motion?
I do.
Very good. I think we can proceed. Does that change anyone else's vote? That amendment? All right, very
No.
good.
Mr. Mulligan, we've gone through all this trouble over a year. I would just suggest to you that you re-vote it with the motion amended as made by Mr. Cole.
I shall. Thank you, Mr. Ford. I'll do that. All right, so we're going to re-vote. Everybody understands we're re-voting the motion as amended. Mr. Kanaga?
Was there a second? Sorry.
Yeah, all right.
I'll second.
Well, you don't have a motion then, but Mr. Cole, you want to make your motion again as amended?
Sorry.
Sure. So I make a motion that we grant the special permit as presented, inclusive of the protocol, 8-item protocol presented, and also a 48 section 6 finding.
Very good. And then Ms. Ico, you have a second?
I will second.
All right. And I'll call the roll again. Mr. Cole,
Yes.
Ms. Ico,
Yes.
Mr. Higgins.
Yes.
I'm also yes. Mr. Todd.
I still abstain. Thank you.
Mr. Ford, anything else we need to do before we conclude this hearing?
I don't think you've done a nice job.
Well,
Really?
thanks to you giving order, and thanks to the cooperation of the two council. I
Thank you all.
Yeah.
Thank you all. Have a good night.
Yeah, thank you. All right, the next item of business is to hear the case 21, what is it? 2146?
2194.
2194, I'm sorry, 2194 Winslow. Mr. Delory. Mr. Delory, you're muted.
Yes,
Thank you.
and I also just put on my video and I don't see myself.
Well, you're there. We see you. So
Okay,
you better behave. You better behave, Mr. Delory. We can see you.
I promise. Okay, yes. I think Stephanie Sequin may be also wanting to.
Would you let Stephanie in if she's there, please? There we go.
Great. Thank you.
Hi, thank you.
Welcome. Mr. Delory, Mr. Higgins, thank you for your vote last time. You're welcome to participate in this discussion, but Isabel Santagru will be voting as the 5 regular members. Mr. Delory, since we have 2 new members who didn't hear your discussion, and since it's been a while, why don't you take us through the application quickly and then talk about the issues that were holding fire when we ended, which was the particularities of the plot plan and then the particularities of the moving of the septic system.
Okay, the project is to add about a 400 square foot addition to number 6 Ewing Drive, South Orleans. And it also includes a deck, which is shown on the plans with the curved corners. That's the deck, and it's 1 story in a basement. It's attached to the existing house at a 45-degree angle, and it uses all of the detailing and massing consistent with the house that it attaches to. It was built about 20 years ago, and it does exceed the it does encroach into the 25-foot setback. That's been discussed quite a bit in these 2 hearings that we've had already, so I don't think I'll dwell on that. That's the basic reason that we came, was a special permit for encroaching into the 25-foot setback.
Right, right. And we determined that those are intensifications and not new and not new non-conformings.
Correct. That's an intensification of the existing non-conformance, which is then allowed. You can intensify it, so that's what we did. We applied for an intensification of an existing non-conforming situation.
And do you want to represent whether this has been a problem for the neighbors for whom it's being intensified, the non-conformance?
I think, and Jen may correct me, but I think that we have 14 letters of support and no letters, emails, messages, or anything in opposition.
And the letters of support include the owners of the property next to it, right?
Correct.
On the border?
The abutters.
Yes.
Uh,
the abutters.
Actually, the primary abutter is also an owner of the project that we're applying for the special permit.
Right. I thought we should put that in the record. You want to talk about the moving of the septic system?
Yeah, I think that someone on the board was questioning whether it was going to be possible, given the shape of the lot. Stephanie Sequin from Ryder Wilcox managed to create an entire redesign of the septic system for the residents, and conforming with all the health department rules and setbacks and quantities, et cetera, et cetera. And she's here to answer any specific engineering questions or anything you see that doesn't make sense on that septic plan.
And these plans have been filed with the health department,
Yes, they have.
but they haven't been acted upon yet, is that correct?
That's correct.
Ms. Seguin,
Yes,
is this, this isn't the health department doesn't require one of these nitrogen reducing systems this close to the bay?
not as of yet. And who knows what will happen down the road, but in this situation, we have a proposed system that fully complies with Title V in Orleans Board of Health requirements. We dug 4 test holes and the soil is excellent. We have no issues with groundwater. So, you know, this is something that is just handled administratively through the health department office.
Okay. So you anticipate this would be approved, but we will probably condition our, if we proceed here, we'll probably condition our approval on getting approval from the health department, of course.
That's fine. I mean, it goes without saying, but that's fine.
All right. All right. Sibel, we've heard this, we heard this case at some length on 2 prior occasions. You've gotten a brief update. I think you have all the materials they had submitted. Are there any questions you have of concern here about this?
Yes, I do, please, if you could clarify, if the board could clarify this for me, because obviously you went through all the details, but from what I see, the existing deck is where there's a non-compliance to the side setback, but the existing building is compliant currently. And they are proposing that the deck have more non-compliance, which I understand, but is this board, do you allow for a compliant structure to be non-compliant? Because that, to me, that seems like a new non-conformity is being created here.
We actually went around and the first hearing was continued, Ms. Santagru, until we got a ruling from the town council, as well as the planning board, that in Orleans, the non-compliance is a setback non-compliance, and that additional the increase in the non-compliance is not a new non-compliance. It's just an intensification of an existing non-compliance.
I see. Okay.
I don't know if that answers your question. Actually the non-compliance is, correct me if I'm wrong, Mr. Delory, but the original non-compliance is to the house itself.
No, I think it's to the deck.
Mhm.
And
Oh, yeah, all right, you're right. I'm sorry, I read that wrong. You're right. Yeah, I stand corrected. You're right. You're right, Ms. Santagru.
question was, does the house have higher priority, therefore, as a structure versus a tacked on deck to qualify for non-conforming? And the answer is yes. It's a structure, period. It's a deck or a house or anything that except for a patio on grade that encroaches into the setback.
If I may,
Please.
if the town has reviewed this, as you said, then I will go by that determination and accept it.
All right, thank you. Thank you.
Thank you.
Any other questions or comments anybody has on this? Lynn, please.
Yeah, I wanted to make a comment for our new members. Because when I'm the most recent new member, I've been on 2.5 years, and I was always befuddled by these things. And just a comment, in the past, we have approved intensification of non-compliance that's relatively modest. I mean, you know, a foot, half a foot. It's been very small. This is bigger than any I've seen in my 2 to 3 years. And I guess I would say the fact that there was no issues from the abutters, at least for me, weighed heavily. Even though the intensification was fairly large, you know, a number of feet, not just inches or a half a foot. So I just say that.
Very good.
It's different than other cases we've seen by folks in the neighborhood.
Thank you. Anyone else have any comments or questions? Like, Mr. Tom?
I thought that Sibel's question was so right on, because it was the very question, or one of the questions that we had struggled with. And so it continues in my mind to reflect a little bit on what Lynn just said about the intensity of the fact that it's an intensification rather than simply a new allowance. And I would like to inquire again, because I don't recall this, when the deck is complete, what's the nearest that will be to whatever water body it is that's protected by the various conservation, health, and et cetera regulations that govern these kind of setbacks?
I can't tell you, Mr. Tom.
Well, it's the proposed deck and addition are completely outside of the 100-foot buffer to the resource area.
When complete, they will be outside the 100-foot setback? Is that what you're
Yes.
saying?
Yes,
All right, thank you very much.
you're welcome.
If it impeded on it would have to go to the Conservation Commission. This doesn't have to go to the Conservation Commission, did it, Mr. Delory?
Yes. What? Oh, I'm sorry. Did I hear you right? Could you say that again?
This application did not need to go before the Conservation Commission, is that correct?
That's correct.
All right. Any other questions?
I just have a question. I think it's an extension of the previous question that was asked. That the existing building itself is 25.8 feet from has more than 25 feet, with the
Right.
current existing deck having just over 17 feet. Is that current existing deck considered non-compliance as of right now? Would we consider that?
That is the original non-compliance, and that was
Okay.
the only non-compliance prior to this proposed new deck. And the new deck is the intensification of that original non-compliance, Mr. Higgins.
Perfect. Thank you.
Any other questions or comments?
Could I please add?
Please.
I think that when such projects are presented, I always try to ask if there was a possibility of doing the design so that you did not interfere further into the side setback and intensify. And in my view, although I had the answer, in my view, a deck is different than the building itself, because there's a huge massing versus just a deck which is on the ground. So there is a difference. And I just wonder if they had no choice but to encroach within the side setback for the building when the existing building was compliant.
I can speak to that. The reason for the angle was to allow the owners who also own the property next door a view to Pleasant Bay. So instead of going to land court, and because the the next door property where the incursion occurred was, one of the owners is on title to that property, but the other one isn't. So it would have had to gone to land court to change the lot line to make a little bubble on that lot line, and which would have been expensive in a longer process. So we thought it was appropriate to ask the Board of Permanent Appeals to zoning appeals to give us a chance to present our case.
All right. You know, just Sibel, the standard in Orleans is that any structure, we have a lot of cases where we consider every structure, because we get a lot of cases where people want to build decks, especially over into the water setback, and so we consider a deck the same equivalence as anything else, because that's where most of the pressures come in this town, is to push against the setbacks required around bodies of water. And the idea that a house is, so we have, I think, a stricter interpretation of, not a stricter interpretation, but a different interpretation than any structure other than, as has been said earlier tonight, other than a patio on the ground, is a structure that requires the appropriate setbacks and approval from the board. You'll see a lot of requests along the waterways to move decks, and the argument is it's very low profile and doesn't cause a problem. But we have rejected that consistently.
Okay.
Yeah,
That's sort of the history of decks and setbacks, at least in the 6 years I've been on the board.
Okay. Thank you.
Well, do I have a motion? All right, just to get things going, I'll move to approve the request for special permit. Is there a second? Is this gonna
Second.
die is this gonna die for want of a second? Did you second, Mr. Cole?
Yes.
All right, there's a second. Any further discussion? I'll call the roll. Mr. Cole,
I'd like to inquire in the intimate and confidential context of the board as to whether the delay in the arrival of the proposal or the second reflected ongoing ambivalence and concerns.
that'll come out in the vote, Mr. Top. That'll come out in the
sorry?
vote.
I'm sorry?
That will come out in the vote.
I thought you asked the discussion.
Everyone was given an opportunity to speak and ask questions. There was a long pause. Nobody spoke, nobody asked questions. So we
I
made a motion,
recognize that.
and any ambivalence of opposition will come out in the vote. We could sit here forever waiting for people to speak who don't speak. We're trying to move this thing, we're trying to end this meeting. If there's no one has any further questions or comments, we've gone to a vote. Let's go to a vote and see where we are. I think any ambivalence or opposition will come out in a vote at this point.
I defer to the chair.
If you want to open, if you want to stop the vote.
No, Jerry,
comment,
please, please.
We waited, I think.
I was curious. The chair has ruled that anything will come out in the vote, and I accept the chair's ruling.
All right, I forget where we were in the vote. Mr. Cole,
Yes.
Ms. Ico,
Yes.
Ms. Asante,
Yes.
I'm yes also. Mr. Tom.
Yes.
Well, the vote is unanimous. Mr. Delore, you have your special permit.
Thank you.
Thank you.
Thank you for all you do for the town.
Well, you're very welcome. There is one administrative matter I'd like to discuss before we adjourn, and that is in addition to reaffirming my welcome.
Good night, Tom.
Good
Tom, good night. Good night,
Thanks,
Tom. Mr. Delory, Ms. Sequin, you're welcome to stay, but you'll be bored. There is an issue, and I should have addressed this earlier, Mrs. Santagro. The retiring board regular member was our clerk. And the clerk's role is very reduced here at this board. All of our decisions, by our rules and practices, all of our decisions require that they be signed by an officer of the board before they're filed. I've been writing all the decisions. For the next month, I'm going to be in Florida. And what happens is I write the decisions, they're circulated by the board at the next meeting. The board accepts them, and then Jen prints them out at the office. But I'm not there to sign them for the next month. So I would ask if you would consider standing for election as clerk, and since you work and live in town. And all it requires is, and it's only for the next month or so until I get back, that, and I think we now have 2 cases. We'll probably have another 1 or 2 next meeting. At most, it'll mean probably 2 visits to the town hall just to sign a decision before they're filed. But because Lynn is the vice chair and I'm the chair and we travel in the winter, we need someone on scene in Orleans. And if you would agree to be clerk, I'd like to nominate you.
All right, thank you. Then I agree. Thank you.
All right, very good. Thank you very much. And I move that the board elect Sibel Santagro to the position of clerk. I'll call the roll because who knows who's out there listening. Mr. Cole,
Yes.
Ms. Eicholt.
Yes, thank you, Sibel.
Yes. And Sibel. Yeah.
Yes,
Thank you very much, Sibel. Congratulations on your
thank you. Wow, I've been moved up to clerk immediately.
the first meeting. You're an officer of the board. Congratulations.
All right, thank you.
Does
Thank
that
you all very much. Thank you
another
all very
another
much
question?
tonight.
The inevitable question from Mr. Taub. Does
Oh,
that
Mr. Tubb, you're off. Your picture is off. I didn't call you. Could I ask
okay.
your vote on that too? I'm sorry.
No, my vote is affirmative. I would like some more almost formal welcome of the new. I've lost the newest other member on my screen.
Yeah, I think she's gone. We had a little more formal recognition at the earlier part of the meeting. That you
Fine,
missed, Mr. Tubb.
fine.
Yeah.
So just, you know, the proof was in the pudding. Their participation was fabulous, and we're very, very grateful that and your efforts too, Mr. Chairman. Thank you.
Well, you're welcome. I just want to comment that the first meeting, I don't know that any new member brought more substance to a discussion in his first meeting than you did, Mr. Higgins. It's obvious that this board has been sadly in need of an engineer. And now that we have one, we have someone who can make us look even better than we are.
I have a question. Is the Higgins and the Higgins have any relationship other than the commonness of their last name? Pardon the word commonality.
I wouldn't be shocked.
Oh, shit. Somebody in the post office ran into me and said, "Hey, my son's on the board. We've just knocked down your average age by a decade."
Yeah.
Your
He has
dad
done it
was
by a
very
decade.
pleased, and so are we. Thank you.
Maybe 2 decades, Mr. Tubb.
I did the math. It's only one.
Oh, okay.
One thing,
I figured
Jerry,
I saw some discussion on engineering,
Yeah.
and I had to give my 2 cents.
Well, I'm glad you did. It always makes us look good when someone
Welcome
speaks.
back,
knowledgeable.
Sibel.
I'm so sorry, I
So-
just got cut off. Sorry, I apologize.
We gave you
so
more responsibilities, no problem.
All right, Lynn, please.
So, Jerry, it would be good if we could have one meeting at least when we're all back in town,
Yeah.
where we actually introduce ourselves live that we voted to go Zoom because it just works a lot better for people, particularly those who are working. But I think it would be nice as the most recent new member, I felt very disconnected, not ever having seen somebody and shaken their hand live. So one meeting,
I
I'd
think
like
that's-
us to consider that when we're
I
back.
think that's very good. I'll be back in the middle of April. And I'll be back till next January. So
Yeah.
I'll collect people's, well, you know, we'll just
Yeah.
see how things go on the
Yeah,
starting in the May meeting, see if we can get a meeting that everybody's gonna be in town. I
Good.
think it's a very good idea. I mean,
okay.
I'm here year round.
very good. Well, thank you all very much for an interesting meeting. And see you in the next April meeting. Good night.
Good night.
I,
Thank you again. And Jen.